coming days. Also, your microphones will be muted, but feel free to put any questions that you may have in the chat box throughout this event, and we'll have our speakers attend to those questions during a Q&A portion. And lastly, I just wanted to thank everybody for joining us. So today you'll be hearing from 3 speakers, the first of which is Kimmy Johnson. She's an administrative coordinator on our Fair Housing team at HCDD, and we are happy to have her on our team because she's the one responsible for bringing these great fair housing workshops to you all. Then you'll hear from our special guest, Mr. Howard Bookstaff. He's an equity partner with Hoover Slovacek, and he's also the general counsel for the Houston Apartment Association. So he's often representing landlords. Mr. Bookstaff frequently speaks at various landlord, tenant, and fair housing seminars, and he is also a fair housing trainer with the Texas Department of Housing and Community Affairs. Our last speaker for this afternoon will be Miss Lisa Everett, who is the staff attorney with the Houston Volunteer Lawyers, where she provides services mostly to low-income residents within Harris County. She has most recently facilitated trainings on the CARES Act and the Texas eviction moratorium during the pandemic. And so we are happy to have both of our special guests with us because they have so much great knowledge to share with you guys today. So as property managers and landlords, we also want to let you know about the Houston Harris County Rental Assistance Program. And while our nonprofits are helping to administer this program, it is a jointly funded program by the City of Houston and Harris County to provide rental assistance for our tenants who have been impacted by COVID-19. And they can also recover by getting their rental arrears paid and also potentially future rent for up to 3 months. And so we are encouraging all of our landlords to enroll in this program today so that we can streamline this application process for our tenants. And if you need more information, please visit houstonharrishelp.org, or you can call the hotline at 832-402-7568. So this customizable training is for landlords and property managers, and it will hopefully provide a comprehensive review of our housing providers' responsibilities under local and federal fair housing laws. And in today's presentation, we will cover the protected classes and transactions under the Fair Housing Act, protections for persons with disabilities, and how to avoid some discriminatory harassment, advertising, resident relations and rules, and the application and screening procedures. So at the end of this workshop, we want our landlords and property managers to embrace how fair housing laws were created and their intended purpose and how to implement them. So we hope that this content will help you understand what kind of issues, statements, and requests could be governed by fair housing guidelines. And just a general note here that this material is for informational purposes only. It does not constitute legal advice. So if you require legal advice at the end of this presentation, please consult an attorney. So with that, let's just talk a little bit more about fair housing and why it's so important. And I'll turn things over to Ms. Kimmy Johnson.
Thank you, Kristen. Good morning, and thank you all for joining us today. Let's just hop right into it. Next slide, please. So Houston is a major renter city, and about half of Houston renters pay more than 30% of their incomes in rent. And almost 1/4 of the renter households pay more than half their incomes in rent. And we refer to this as cost burden. So a family that is cost burdened means that they'll have fewer financial resources to pay for other things they need, such as healthcare, education, or food. So now let's talk about how much it really costs to live in the city of Houston. A minimum hourly wage job in Texas is only $7.25, which means that the minimum wage worker would have to work 115 hours to afford this rent, which means they'll have to work at least 3 full-time jobs. So Houstonians must earn $21.02 an hour to pay for an average 2-bedroom rental home. Where you live definitely matters, and housing plays a significant role in determining your quality of life because it directly affects your access to your transportation and your recreation in neighborhoods, housing that's within your budget, your social, cultural, and educational opportunities, your employment, your medical care, and entertainment opportunities. So here's an example. Children whose families that move to neighborhoods with better access to these opportunities by the age 13 earned future higher earnings than their peers and had higher college attendance rates. So simply put, housing discrimination restricts your access to all of these opportunities. You must provide equal treatment to people who are seeking a home. The Fair Housing Act prohibits acts such as the following. So, one, landlords or lenders cannot steer a Black family from renting or purchasing a home in a predominantly white neighborhood simply because they are Black. Landlords cannot include different terms or conditions in leases or loans, such as imposing higher interest rates for loans for Hispanic persons. Landlords or realtors cannot produce discriminatory ads like ads that say no children or only provide ads that are in English in an area highly populated by people who speak only Spanish. And finally, landlords cannot say that certain housing is unavailable based on a protected class. And for example, that's saying that a second floor apartment is unavailable to a person in a wheelchair when it is actually available. So housing professionals may agree that discrimination towards protected classes may not generally be as blatant as it was over 50 years ago. However, it's still an ongoing problem. And it's important to know the difference between each protected class and ensure that your tenant selection process and overall housing policies don't discriminate based on membership of any of these groups. So to review, the 7 protected classes include race, color, national origin, familial status, religion, disability, and sex. In this January, under the president's executive order, HUD announced that it will administer and enforce the Fair Housing Act to prohibit discrimination on the basis of sexual orientation and gender identity under the protected class of sex. And Howard will talk a little bit more about this later on in the presentation, so stay tuned. It's important to understand how the fair housing laws impact your policies and your daily practices. And by becoming familiar with these following guidelines, you can maintain compliance with the law and conduct your business with fairness. So let's jump into it. This slide is an illustration of some of the common discriminatory practices that take place in rental housing transactions. And we're going to touch on each one of these in the next few slides. So here are a few statements of some commonly used statements that can be considered discriminatory. And such statements may be overt, such as "we don't rent to your kind of people," but however, more often discrimination is hidden in language such as, "oh, if I were single like you, I would want to rent where it's safer," or "I don't think you'd be happy in this neighborhood," or "would you feel safe living on a busy street like this with your young kids?" Or even, "typically we reserve these first floor units for our tenants with younger kids." And so often this language is used to dissuade certain tenants from inquiring further about rental, and it is illegal. So with advertising, you may be wondering, why are fair housing guidelines for advertising even a thing? But the fact is, if you work in the housing industry, regardless of your position, you're most likely advertising on a daily basis. And HUD provides advertising guidelines for compliance, which we'll cover in the next 2 slides. Advertising under the Fair Housing Act includes anything that you make, you print, publish, such as applications, signs, posters, brochures, billboards, or even pictures in your office. And it includes such things that you mention about your property via email, on the phone, or even in person. So while ads may describe the attributes or the amenities of your property, property. And there are certain buzzwords that you should avoid using because they've been associated with some discriminatory practices in the past, such as restricted, exclusive, limited, and so forth. And so, for instance, you cannot advertise that housing is only for a certain racial or ethnic background or exclude families with children with ads that say no children. So your promotional material should include a variety of protected classes. And for instance, just because the neighborhood surrounding your property is made up of residents of a certain background, or the majority of your tenants have a similar background, it doesn't mean that your ad should be limited to only those individuals. And landlords must provide truthful information about the availability, the price, amenities, and features of a housing unit, and ensure your policies and procedures are up to date. The Fair Housing Act itself does not require the use of the equal opportunity logo or slogan, equal housing opportunity, in any ad. However, using the logo regularly is good evidence of the company's commitment to fair housing compliance. So, the criteria that's used to determine whether a person is qualified to rent a home should be objective and applied consistently to all home seekers. It's good practice to have a written policy that contains this criteria and may also include occupancy guidelines, the availability policy, and an outline of the application process. So in order to determine if someone is a qualified applicant, some questions may be asked regarding income, employment history, credit, criminal history, and rental history, but it's important to offer the same terms and conditions to all applicants, which includes deposits or fees, the lease terms, and access to the amenities. So in order to avoid trouble with fair housing laws, please be sure to be consistent and fair in your screening. So what is steering? Steering occurs when a landlord or real estate agent attempts to direct a home seeker to a particular area based on their protected class. And in the rental market, this includes directing a particular tenant towards one section of the apartment complex or to a particular floor. Discouraging someone from living in a particular neighborhood by exaggerating the drawbacks or failing to mention amenities can also be considered steering. So to avoid it, it's best to show all available properties to all home seekers. Allow the home seeker to make decisions about which property should be viewed or if the property is a good fit for them. In addition, housing professionals should only present facts about the property, not about the residents or the neighbors. And so home seekers will often inquire about the neighborhood or ask for information about the schools, the crime, or the demographics, but you should direct them to a reliable resource, such as the local school district, the police, Census Bureau, to obtain that information. Now we'll cover some property rules and policies. So with regards to property rules, it is acceptable for landlords to have a set of basic and non-discriminatory house rules for all residents to follow. But these rules must be enforced uniformly for all residents, and records regarding the violations need to be kept. All details need to be included on the record, such as the time, the date, the manner of the violation, and how you, the landlord, became aware and what actions were taken to enforce the rule. Access to common areas, including the pools, the gym, the laundry facility, they shouldn't be restricted only for certain residents, such as children or persons with disabilities. This is an area where language access can be a problem. And a best practice would be to translate rules into the tenant's native languages, but don't rely on minor children to communicate property rules to parents. Housing providers are responsible for the behavior of their staff, and it's recommended that an anti-harassment policy be created, distributed, and enforced. Harassment can include verbal or written comments, some threats, offers to exchange housing services for sexual favors, or even destruction of property. Some tenant on tenant harassment should also be taken very seriously, and any behavior that violates a resident's code of conduct should be documented and appropriately addressed. So staff should also respond in a timely manner and have consistently enforce the policy and involve law enforcement or other resources when it's necessary. One final form of housing discrimination is retaliation. And retaliation means to pay back an injury in kind. It's you hurt me, I'll hurt you. And retaliation against someone that's filing a fair housing complaint could include things such as increasing the rent, turning off their utilities, or terminating their lease. So for the most part, property managers don't blatantly retaliate against residents who exercise their fair housing rights. So for examples, managers may not say, oh, because you filed a fair housing complaint, I'm going to evict you. Usually there is no such smoking gun, and rather retaliation is frequently much more subtle. So for example, a resident who may file a complaint may suddenly find his maintenance request being ignored, and this could support evidence of retaliation in a complaint. And so it's also unlawful to retaliate against anyone because they assisted someone with filing a discrimination complaint. An example of this would be if a landlord evicts a resident who helps someone file a fair housing complaint against a property, or because they were a witness in an investigation. And finally, note that retaliation covers not just residents, but also protects employees who assist residents with a complaint. And management can't take adverse action against an employee without risk of violating the statute. You should always consider the potential for retaliation charges if you are about to take an adverse action against any resident who's exercised a fair housing right. So in order to determine whether an action could be considered retaliation, you may want to ask a few questions such as, would I take this action if they had not exercised their fair housing right? Would I be taking the same action if it were another resident? Or have I responded in the same way when other residents have done this in the past? If the answers to any of these questions is no, or you have not documented the situation very well, you should probably not take the proposed adverse action because it can be perceived as retaliation. And finally, all employees are required to comply with fair housing laws, including maintenance and office staff. Fair housing training should be provided for all employees and incorporated into the training process for new employees. These policies should be documented and communicated to all employees and may need to be reviewed on a regular basis. Owners and landlords can be held responsible for the actions of their employees and may be held responsible for their team's discriminatory statements and behavior. So this concludes this portion of the workshop. At this time, I'll turn it back over to Kristen to introduce our next presenter. Kristen?
Thank you, Kimmy. That was a lot of great information about the fair housing basics. So now we're going to turn things over to Mr. Howard Bookstaff, who will discover housing discrimination, accommodations and modifications.
Thanks, Kristen.
Go ahead, Mr. Bookstaff.
Thanks, Kristen. Great job, Kimmy. And welcome to everybody. Thanks to the city and the county for having me participate. We are going to talk about, next slide. One thing I always have to say is, next slide. We can't give legal advice up here. You're going to hear from some attorneys, but you're not getting legal advice. You're getting general information that hopefully will help you navigate different fair housing issues at your properties and in your office and in your life. And so don't take nothing confidential here. We have about 200 or so people on the call. So nothing at all confidential. Next slide. Okay, I really enjoy talking about this topic, fair housing in general, because it covers everything you do in the ownership, operation, management, maintenance of an apartment community. And Kimmy touched on a lot of the general things, the basics that you do need to know. What I'm going to specifically address is providing reasonable accommodations and modifications. What's interesting, and Kimmy said the protected classes, there's 7 protected classes federally: race, color, religion, national origin, sex, milieu status, and disability. And you'll never guess which is the most common type of complaint. Think about it, think about it, think about it. It's not race, it is disability. HUD came out, well, TWC came out with its annual report from 2020 recently, and it said that 62% of its complaints were based on disability, which is, of course, reasonable accommodations and modifications issues. HUD, or the assistance animal notice that came out January 28th from HUD, said that 60% of HUD's complaints were disability-related complaints. So that tells us that disability, being the most common type of complaint, is really what we want to train you on the most. And there's a lot of stuff in here that is not necessarily common sense. You need to learn how to respond to reasonable accommodations, modifications, and what the ins and outs and the nuances are of this particular area of fair housing. Next slide. Key to knowing about reasonable accommodations and reasonable modifications is knowing who qualifies as a person with a disability under the Fair Housing Act. You do not get an accommodation or modification under the Fair Housing Act unless you have a disability under the Act. If somebody says they're not disabled, but they ask for something, it is not a request for an accommodation or modification under the Fair Housing Act. So what's very important is that we know. Even when I train this stuff, I make people memorize at least the first bullet point here. What is a disability? It's and we talk about the difference between disability and handicap. What's the difference? People say one's physical, one's mental. It's nothing. Nothing is the difference. It's the same thing. Handicap and disability are different words to describe the same thing. A lot of the HUD rules and the statute are written with the word handicap. Disability is a more, and HUD even said this in a guidance, HUD disability is the more politically correct way to now say it. So you can say it either way, but disability is what they use now, handicap is what they used before. So it's individuals with a physical or mental impairment that substantially limits one or more major life activities. So this is very important to memorize. Individuals with a physical or mental impairment, so it's both physical and mental impairment, that substantially limits one or more major life activities. I look at like 3 parts. Part 1 is it's a physical or mental impairment. Part 2 is it's a substantially limit, not sort of limit, not kind of limit, substantially limits. And then you have one or more major life activities. And HUD does describe what a major life activity is by saying it's your ability to function, its ability to feed yourself, to clothe yourself, to be a member of society. It's a major life activity. And then it adds on to individuals who are regarded as having such an impairment, or individuals with a record of such an impairment. But again, I focus on that first sub-bullet point: physical or mental impairment substantially limits one or more major life activities. And we will hit on that a couple of times throughout, especially when we talk about what everybody wants to talk about, which is assistance animals. We'll go through those in a few minutes. Next slide. Okay, what is a reasonable accommodation under the Act? Well, this is the HUD, what HUD says in its rule. A reasonable accommodation is a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with a disability to have an equal opportunity to use and enjoy a dwelling, including public and common use spaces. So what does all that mean? I drill it down real simply. A reasonable accommodation, you have to have two things. You have to have some sort of rule, policy, or practice, and then a request for an exception to that rule, policy, or practice. So accommodation takes two things, two components, a rule and an exception to that rule that's requested. So it's just an exception to a rule. Next slide. What is a reasonable modification? So the two things we have to know about are accommodations and modifications. A reasonable modification is a structural change made to existing premises occupied or to be occupied by a person with a disability in order to afford such person full enjoyment of the premises. What does that mean? Again, drilling it down to its most simple form, a reasonable modification takes some sort of a structural change that the disabled person needs in order to enjoy the premises. So we have accommodation being an exception to a rule, and we have modification being a structural change to the premises. Next slide. Now, modifications have a little more to them. The general rule is that it is unlawful for any person to refuse to permit at the expense of the handicapped person. I'm taking it from old school, the rule, so it says handicap, you can substitute in disabled if you'd like. So expense of the disabled person, reasonable modifications of existing premises occupied or to be occupied by a handicapped person if the proposed modification may be necessary to afford the handicapped person full enjoyment of the premises of a dwelling. So what is the shocker here for somebody who's asked for a modification and maybe has read the ADA? And they said under the ADA, the owner of the property has to pay for the modification. Why are you saying I have to pay for it? The ADA is not the Fair Housing Act. That is something that is different. The ADA covers places of public accommodation. So while there could be some places of public accommodation in your normal run apartment community, such as the visitor parking lot, the office that's open to the public, anything behind the gates, behind the fences that deals only with residents, where only residents and their guests can go, like the swimming pool, the walkways, that's all not ADA. That's not a place of public accommodation typically. That is subject to fair housing. So a modification under the Fair Housing Act generally says that it's unlawful to refuse to permit at the expense of the person. So that is a little bit of a checks and balances. They may not want the elevator leading from the first floor to the third floor if they understand they have to pay for it. So that's kind of a checks and balances. Now there are some exceptions to the rule under the Fair Housing Act that modifications are paid for by the disabled person. Next slide. One of the exceptions is under Section 504 of the Rehabilitation Act of 1973. This deals with certain types of government-assisted housing. So if you have government-assisted housing, you need to confirm that you're not subject to Section 504 if you're wondering who would pay for a modification. Next slide. And there's some more exceptions we'll talk about in a second. The Fair Housing Act also says where it is reasonable to do so, the landlord may condition permission for a modification on the renter agreeing to restore the interior of the premises to the condition that existed before the modification, reasonable wear and tear accepted. Now there's a couple of phrases in here that are very important. One is condition permission for a modification on the renter agreeing to restore the interior of the premises. So for example, let's say somebody wants to put in a ramp between, there's a little threshold between the living room and the bathroom, and somebody wants to put in a ramp there. Okay, so because it's a ramp, it's a modification, a structural change. Who pays for it? Well, the resident pays for it unless you're subject to an exception to that rule. Can you require the resident to put the unit back to the way it was? Well, maybe. Okay, it's on the interior of the premises, so you got a shot. But there's another phrase at the very beginning of this slide, where it is reasonable to do so. Take an example that HUD actually gives an example in its materials. Let's say a person in a wheelchair wanted to widen a doorway from the living room to the bathroom. So who pays for that? Well, it's the person that pays for it unless an exception applies. So the disabled person has to pay for the widening of the doorway. Then the question comes up, can you require the disabled person to make the width, the original width, in other words, narrow the doorway when they leave? What the courts have said is that and HUD has said, it is not reasonable to require that because the next person can use that the same way that the disabled person could use it. And that's not, again, not necessarily common sense. It's something we learned from the HUD materials. Correspondingly, let's say a grab bar. Somebody wants a grab bar in the commode. Who pays for it? Well, it's a modification, and therefore the resident has to pay for it unless there's an exception that applies. Can you require the resident to remove the grab bars at the end of occupancy? Well, strangely enough, even though one could argue the next person could use the grab bars as well, HUD says, no, you can require them to remove the grab bars, but you can't require them to remove the blocking behind the wall which supports the grab bars, because the next person doesn't even see the blocking behind the walls, but the person does see the grab bars. So that's, again, not common sense. It is something we learn pursuant to the HUD documents we read. And so really you have to be able to know these. And if you have a situation where it is questionable or you have questions, get help. Get help from other members of your team, supervisory personnel at your company, your legal professional, whatever, but get help to understand that. Because again, just by using your common sense may not get you there. Next slide. Okay, there is a some key exceptions to these rules. If you are a tax credit property, and I've devoted a few slides to discussing the tax credit properties, but I give you the reference to the rule I'm talking about. It's TDHCA Rule 1.204. Basically, talks about accommodations as both what we've been referring to as modifications and accommodations, which means if you're a tax credit property, for the most part, there is no rule that says modifications are paid for by somebody else. It's your nickel as an owner. Okay, and there's some details in these slides. You have to respond within 14 days of a request for an accommodation. And again, accommodation in this rule applies to accommodations and modifications. Next slide. And really, I don't need to bore you with the details of these slides, but know that if you are a tax credit property, Rule 1.204 needs to be reviewed on the issue of providing accommodations or modifications. Next slide. Let's go on, next slide. Okay, another kind of red herring that you have to know about is there are certain rules regarding design and construction requirements. This is for properties that were built for first occupancy after March 13, 1991. Okay, so if you were built after that time and somebody asked, let's say, for an accessible route around the property, well, that was already required to be built that way. So you wouldn't ask them to pay for that modification because the property should have had that to begin with. And I give you some of the details here. If you look at near the bottom, built with the units with accessible feature, all doors designed to allow passage into and within all premises of covered dwellings must be sufficiently wide to allow passage by persons with disabilities. So if somebody asked to widen a doorway when it should have been widened anyway because the property was built after 1991, then you're not going to ask them to pay for it. So again, not common sense. This is just the rule that you have to follow. Light switch, go to third from the last bullet point. Light switches, electrical outlets, thermostats, and other environmental controls in accessible locations. If you don't have that and somebody asked for that, you did not build the property the correct way, so you've got to go ahead and do that without charging somebody for the modification. Now, if the property is built before 91 and you weren't otherwise required to do it, then yeah, it's a modification that you can charge somebody for. Next slide. Okay, again, additional TDHCA. Now this goes with rules 1.205 to 1.211. So the whole plethora of rules for the TDHCA, if your tax credit, look at 1.204 to 1.211 for the fair housing accommodation and modification stuff. Next slide. Responding to requests for accommodations and modifications. Again, this is key. I put this in because a lot of times we see the complaints being made because there weren't the proper responses to these requests for accommodations and modifications. Next slide. This is very important. The request, you can request that the request be made in writing, but the Fair Housing Act does not allow an owner to require the request in writing. HUD even says that it's a good idea to request it in writing because it clarifies the communication between you and the requester, and it clarifies what the request is. But you cannot say no if they don't put it in writing. So if you have a form that you want people to fill out, that's terrific. Forms are great. You cannot say no if they say, I'm not going to fill out your form. Okay, so do not do that. Next slide. Even though you can't require that somebody put their request in writing, you can certainly respond in writing. And in a response, I've kind of put, this is my doing, not HUD doesn't tell you to do this. This is my way to respond. I reiterate your policy. What's your policy? We comply with all applicable fair housing laws. Accordingly, if you're after, we allow reasonable accommodations. And I go back to the slides that we talked about what reasonable accommodations are, and I put that in my letter. That's my policy. If it's a modification, I do the modification policy. Confirm the request. This is where they don't have to put it in writing, but you can certainly confirm what their request is in writing. And this is often beneficial, especially when they ask for a modification, because where is the parking space supposed to be? Where is the ramp supposed to be? You can confirm that in this part of the response. Then you respond to the request. Obviously, you got to respond to the request, and I figure there's three options: grant, deny, or request more information. I err on the side of not denying, which leaves you with granting or requesting more information. So if you're inclined to say, now there's something screwy with this request, I need more information, ask for more information. Don't deny it, and say, before we can grant your request, we'd like to know this information, and go about it that way. Next slide. Okay, and your request for more information can take three things you're allowed to ask for. And always start with the second line of this first bullet point, reliable disability-related information that is necessary to verify the person meets the Act's definitions of disability, reliable disability-related information that describes the needed accommodation or modification, and reliable disability-related information that shows the relationship between the person's disability and the need for the requested accommodation. Guys, this should make sense to you. We already said you got to have a disability, so you can ask them for information that's necessary to verify that they meet the Act's definition of disability. You're not entitled to know the nature and severity of the disability. That gets into privacy issues. You are entitled to know that they meet the definition of disability under the Act. Describe the needed accommodation or modification. You're entitled to know that. Shows the relationship. In other words, the connection. What's your disability-related need for this accommodation? You are entitled to know that. And again, all of these are if it is not known or obvious. Next slide. Request for modification, you have to go a little further. As we talked about, who's going to pay for it? For the first time, the requester may have to be told that they're going to pay for it. State whether you require restoration and whether you're going to require a restoration agreement. Okay, next slide. Now we are talking about what everybody seems to want to talk about, assistance animals. Next slide. Okay, HUD came out, and a lot of people missed this because we had something else happen in March of last year that took everybody's attention. But right before March, January 28th, the end of January, HUD came out with a new guidance on assistance animals. So a lot of the stuff that I'm telling you now came out of that guidance. HUD breaks it down into two types of animals, which may or may not be helpful. I didn't find it that helpful. Maybe it'll click for you, didn't click for me. two types of animals: service animals, which is a dog that's individually trained to help a person with a disability. Okay, so you're like, great, all we have to worry about is dogs. Well, no, because HUD says the other category is other animals that do work, perform tasks, provide assistance, or provide therapeutic emotional support for individuals with disabilities. So when you get down reading both of these, it's still any animals that provide assistance to somebody with a disability can be an assistance animal. Next slide. Questions to be asked to determine a service animal. Again, a service animal is only a dog, not a cat, not a snake, not a monkey, not a goldfish, just a dog. And if it's not readily apparent, all these guys are if it's not readily apparent. If it's readily apparent, if you have a seeing eye dog with a blind person with a cane, you don't need to ask them or have them prove that they're disabled under the act. They are disabled, okay? And if you have a dog with that's obvious that you know the use of the dog, that the dog is trained to help this person with disability, don't ask about it. But if it's not readily apparent, is the dog required because of the disability? If it's not readily apparent, what work or task has the dog been trained to perform? And if the answers are no or none, then it's not a service animal. But again, just because it's not a service animal doesn't mean it's not an assistance animal where all the trappings of the rules about assistance animals still apply. Next slide. If the animal is not a service animal, if it's not apparent, does the person have a disability under the act? If it's not apparent, does the animal work, perform tasks, provide assistance, and/or therapeutic emotional support with respect to the individual's disability? Guys, this should sound familiar to you. A request for an assistance animal is nothing more or less than a request for an accommodation under the act. All the rules we just talked about apply. You can ask three things. Do they have a disability under the act? Verify disability under the act, confirm what the request is. In assistance animals, we normally don't need that one because they tell you they need this assistance animal. Fluffy the pit bull is my assistance animal. We want Fluffy. Okay, so we don't go to number two. But number three, what's the relationship between the disability and the need for the accommodation? That's what, in other words, that's what the second bullet point is doing. Does the animal work, provide tasks, provide assistance, or emotional support with respect to your disability? Next slide. What information can be requested? Again, this is all, it's review as far as again, the disability under the act and the disability related need, but HUD goes a little further. Does the resident have government determination of disability? So if there's a government determination of disability, such as disability benefits or services, Medicare, Social Security insurance, benefits, things of that nature, then they're going to be disabled under the act. Doesn't mean they get the assistance animal. They got to pass the other prong, which is a disability-related need for that animal. Next slide. Documentation from the internet. Very interesting. HUD went here in the January 28th, 2020 guidance. The first two bullet points, HUD says, some websites sell to anyone who answers questions and participates in a short interview and pays a fee. Such documentation from the internet is not by itself sufficient to reliably establish that an individual has a disability or disability-related need for the assistance animal. Stop there for a second. So HUD is saying this stuff you've gotten from the internet for $64, $99, $99, $90, that doesn't necessarily in and of itself means it's a valuable thing to show disability or disability-related need. But then HUD goes on to say, by contrast, there are legitimate licensed healthcare professionals that deliver services remotely. I will say this was before COVID that they said this. Now we probably have all had doctor's visits virtually, so we know this. But then they say one reliable form of documentation is a note from the person's healthcare professional that confirms the person's disability or need for an animal when the professional has personal knowledge. So underline that because that's the key really between what people buy off the internet. I've never been to California, but I got this doctor in California that wrote me, the $64 registration certificate for my dog. Okay, well, you can question that. Okay, if it's apparent that whoever wrote that doesn't have personal knowledge of the individual, that could be something you could push back on. Next slide. What is reliable information showing the disability-related need? And this goes into healthcare providers, everything from a nurse to the physician, all these healthcare providers who you're looking for with a note. It's not exclusive. You can get someone other than that, but that's what HUD has included in their list. And you're looking again for the connection between the healthcare provider and the disability and the individual with the disability. And then you're looking for the connection between the disability and the need for the animal. Next slide. Okay, more again, and you can Google I know I'm running short on time. You can Google this, the HUD guidance from HUD guidance on assistance animals, January 28th. If you're interested in this or you have questions on a particular matter, I give a lot of my advice based on what HUD has said in its guidance. So it might be valuable for you to look at this if you have questions about the documentation and all that. It is not a fail-safe, way to do it, but it is what HUD has suggested, and it's not going to be black and white. It's like a wiggle room in what HUD has suggested. But nonetheless, it is somewhat valuable. Next slide. Okay, pushing back. A lot of my clients ask me, I think this is a hokey situation. It was an unauthorized pet in day 1, and day 5, suddenly it's their assistance animal. What's going on? Well, a federal district court case in 2017 actually supported an apartment owner's effort to deny a request for an assistance animal. And I thought this was interesting. The apartment owner received letters from the resident in support of their request, stating these last 2 bullet points. The resident needed a therapy dog to help her cope with mental health condition, had a mental illness, as such had certain limitations. Next slide. These are a lot what we see in this stuff. The resident was impaired by her mental illness, the definition of disability. They met the definition of disability under the ADA and the Fair Housing Act. The court said that the letters identified no activity, no less a major life activity. Those words, remember that in that we memorized that definition in like the first slide. And that the resident claimed to be impaired by her mental illness. It was more conclusory than the information provided failed to set forth facts regarding how any of the resident's conditions substantially limits. Okay, another buzzwords from our definition. Remember, it's a physical or mental impairment that substantially limits a major life activity. The court used those words and said the proof that the resident gave in support of their request for an accommodation of the assistance animal did not meet what the court decided was prove that they substantially limit a major life activity. Bottom line, bottom slider, bottom bullet point, if you're not satisfied with the information provided, you can ask for more information. Again, I err on the side of not denying, but I've asked for more information plenty of time, and I explain it by saying, understand that we've gotten a lot of fraudulent requests. We're trying to verify your request is legitimate, therefore we need this additional information. Next slide. Okay, real quick on criminal history. HUD weighed in on criminal history in 2016. Next slide. And this is another thing you can Google, HUD's guidance on application of Fair Housing Act standards to the use of criminal records. If you do HUD's guidance on criminal records under the Fair Housing Act, April 4, 2016, it'll come up. So what HUD basically said is that when you're deciding to screen people based on their criminal history, you got to be careful, because HUD has concluded that African Americans and Hispanics are more proportionately arrested for crime than their proportion in society as a whole. And therefore, if you have certain criminal records, like if you've been arrested for a crime or if you've been convicted of any crime, and that's it, and you don't drill down further than that, that could be deemed to be discriminatory under a disparate impact discrimination analysis, which is you have a discriminatory effect of your policy, not necessarily a discriminatory intent. Next slide. Next slide. Okay, what HUD suggests, the bottom line on criminal history criteria is make sure you decide your criminal history criteria based on the types of crimes. In other words, more significant crimes would have a longer period when they occurred, a look back period that's longer. For example, murder or sex offense, I say you can't get in, period. But if you've had a lesser felony conviction, maybe after 6-7 years, and you've been good in society, then you could get in. So you need to pay attention to that. HUD does not give you details as far as what types of crimes and what look back periods. HUD simply suggests that you evaluate different types of crimes differently and have different look back periods for different types of crimes. HUD also suggests an individualized assessment. If somebody's denied, you look at them in the eye and you say, okay, tell me about your history, and are you good now that you may not have, are you fully recovered from your criminal history that we can rely on you as being a good resident. So this is food for thought when you go back, look at your rental criteria and your criminal history criteria, and see if you pass muster under this disparate impact analysis, where you have types of crime separated, look back periods, and create some sort of an appeal or an individualized assessment if somebody is denied. Next slide. Okay, finally, I'm talking about, I'm all caught up in my dates. I'm talking about January 20th, 2021. So this just happened, that when President Biden got into office, he signed a slew of executive orders his first day, one of which dealt with this issue. It did not create gender identity, sexual orientation as a protected class. What it did is it directed federal agencies to consider whether their actions what actions they could take to ensure that it is fully implementing a policy which was that equal treatment under the law, no matter a person's gender identity and sexual orientation. And it relied on a U.S. Supreme Court case, which was actually an employment case, not an apartment case, not a landlord-tenant case, that says that discrimination, the prohibition of discrimination because of sex covers discrimination on the basis of gender identity and sexual orientation. Next slide. So it's important to understand that, well, before I say that, HUD followed, so the executive order from President Biden was January 20th. HUD, where he directed all agencies to do something, HUD responded. HUD followed with its own memorandum to its offices. So it's not really to the public. Public got a hold of it, but it's to HUD's offices how they're going to enforce the Fair Housing Act. And that was February 11, 2021, where they directed all offices to when there's a prohibition based on sex is a prohibition based on discrimination against gender identity and sexual orientation. Okay, so it does not create new protected classes. We still have the 7 protected classes. HUD can't do that. That's legislation. But what HUD has done is it sort of encapsulated or adopted the U.S. Supreme Court's ruling in an employment case to allow gender identity complaints and sexual orientation complaints to be enforced under a sex discrimination analysis. And with that, next slide, I think I am done. Yes, thank you for your participation. I know we'll get to questions after Lisa has presented. Thanks, Kristen. I turn it back over to you.
Thank you so much. So now we are going to hear from Miss Lisa Everett. She's going to give an overview of the fair housing complaint process, as well as how the eviction process and the moratorium affects tenants. And as Mr. Bookstaff said, we're definitely going to have a question and answer period after Miss Everett gives her presentation. So if you do have questions, please put those in the chat box. Miss Everett, the floor is yours.
Thank you. Can we go ahead and start the presentation? And thank you, Howard, for a good presentation. I enjoy it as well. Can we go to the next slide? So I'm from Houston Volunteer Lawyers. We serve low-income Houston and Harris County residents with their civil legal needs. That includes estate planning, probate, guardianship, landlord tenant, which is why I'm here today, veteran issues, some consumer issues, and we do limited family law issues. In case you're wondering, if you're wanting to refer your tenants to us, we do serve citizens and non-citizens. Next slide, please. Houston Volunteer Lawyers is also a member of the Eviction Defense Coalition, which also includes Lone Star Legal Aid, South Texas College of Law at Houston, the Earl Carl Institute at Thurgood Marshall School of Law, and the University of Houston Law Center. Can you go 2 slides ahead? Thanks. Sorry, I got my slides mixed up when I inserted the rental assistance. So if you want to refer anyone, this will be going to everyone, but if you want to refer any of your tenants to us, sometimes people find it easier to deal with tenants, maybe when they're being represented by someone. Sometimes people just need the intermediary to make it a better process. Then please feel free to refer any of your tenants to us, and they can apply or call. Can you go back 1 slide? Just like Kimmy mentioned at the I believe it was Kimmy mentioned at the beginning. Someone's saying they can't see my slides. I can see it. I'm just going to go on. If any of your tenants are unable to afford rent, there is a ton of money coming in through HoustonHarrisHelp.org and also at Texas Rent Relief. There's landlord enrollment for both programs. If you enroll, then you receive the payments directly. Under both of these programs, you can receive future rent as well if the tenant maybe is still getting back on their feet and needs future assistance as well. They both offer a lot of money potentially to you if you've been unpaid for a while. So I encourage everyone who has unpaid rent to sign up and encourage the tenant who is delinquent to sign up as well. Okay, can we go forward again? And okay, thank you. So today we're going to do a brief overview of the fair housing complaint, and then I'll do a brief overview of evictions. Next. So under the fair housing complaint, an aggrieved person can file a complaint, and that's a person who claims to have been injured by a discriminatory housing practice. And so that would be what Kimmy described earlier. Or potentially things that Howard was talking about, like denying someone a reasonable accommodation or modification. Or it can be a person who thinks they will be injured by discriminatory housing practice. And so that would be like if someone were to move in somewhere and they say, oh, and I'm going to have to install a ramp. And then you say, no, you can't move in. That would be someone who believes they're going to be injured as an example. The U.S. Attorney General can also file complaints. Next. In the Houston area, the Texas Workforce Commission, who I think we associate much more with unemployment, actually handles complaints for HUD. If you're in other areas of Texas, HUD handles it directly, but for Houston and Harris County, it is the TWC. They prefer an online application, and generally speaking, the complaint should be filed within 1 year of the discriminatory practice, or anyone can file a civil suit in federal or state district court, and that should be filed within 2 years of the discriminatory practice. In some circumstances, not this, people have to exhaust their administrative remedies, which means they have to go through the administrative agency like HUD or the TWC. In this case, they do not have to exhaust the administrative remedy, meaning that they can file directly in court if they want. Next. So the way the process works is the complaint is filed. The TWC will then notify the other party, which would be the landlord or the housing manager, housing owner, about the complaint and give them an opportunity to respond to the complaint. The TWC will then offer mediation. It's not required, and only if both parties agree. Then the next step is for the TWC to I'm sorry, I'm looking at comments. I'm going to turn off my comments for just a second so I can't see them. The next step is for the TWC to investigate. It's possible that they can recommend that the Texas Attorney General file suit. But after the investigation, there's normally a process called conciliation. And it's sort of like mediation. It's where the TWC tries to broker an agreement, for lack of a better word, of what between the two parties. And it also takes into account the interest of the public. And so that normally takes the form of maybe educating the landlord or the property manager regarding about fair housing process, so they don't repeat it in the future. It can also involve penalties to discourage that type of behavior in the future, like that goes to the state, or and also, of course, to the aggrieved party as well. And just so you know, a breach of the conciliation agreement is also is another breach that can be prosecuted, and people, or you can file a new complaint or file a suit based on a breach of a conciliation agreement. If there's no conciliation agreement reached, then the person making the complaint can file a request for a reconsideration review, or they can file suit in court as well. Next. So under the fair housing, the remedies include injunctive or equitable relief. And injunctive means like forcing someone not to take an action or to take an action. And so, like, for example, if you say you can't rent here because you wanted to install a ramp, it would be ordering them to let someone move in, even though they're going to install a ramp. It can also include compensatory damages, and that means money. It can include punitive damages, which is money. It can be a civil penalty, and that's what I was talking about, where it goes back to this to the state to discourage that kind of behavior. And it can also include reasonable attorney's fees and cost. Next. So that was an overview of the fair housing process, and now we're going to do a very, very brief overview of evictions. So whenever anyone is contemplating evictions, what they need to consider generally is the lease agreement, the Texas Property Code, and there's 4 sections of the Texas Property Code that apply to that apply to residential tenancies in Texas. And 91 is a very general, and 92 is it's just general provisions, and it talks about, like, when a lease ends, it rolls over and becomes month to month, and how to terminate a lease. 92 is a very, very wide look at residential tenancies. 94 is specific to manufactured homes or mobile homes, and 24 is the forcible entry and detainer statute, which is more commonly known as evictions. And then the other thing that applies in Texas are the Texas Rules of Civil Procedure. All of our evictions are brought in JP court, and so that's governed by rules 500 through 510 are the JP court rules, and 510 specifically applies to evictions. Next slide. So in an eviction, the issue is who has a superior right of possession. And so when a landlord sues, they're actually suing for possession, and they're asserting that they have the superior right to possess that property. In the eviction, you're also allowed to request unpaid rent, the cost of court, and attorney's fees if you have them. Every now and then I see property managers that request attorney's fees, but there's no attorney on the case. You don't get attorney's fees if you're not an attorney. There are no counterclaims in evictions. Every now and then, people come to us wanting to countersue their landlord normally for repair issues. There are no counterclaims in evictions. If there is another suit, it has to be brought separately and independently of the eviction. And so if you're ever wondering why you're not countersued, it's actually because the rules prohibit it. Next. In the eviction, first there has to be a breach of the lease. You don't get to kick someone out in the middle of a lease term if there's not a breach of the lease. Every now and then we see it very, very occasionally where someone just maybe an owner wants to move back into their home or wants to sell the home, and they try to evict someone in the middle of the lease for no reason. That's why you have that's the contract. That's the terms of the contract. Just like the tenant can't move out early, you can't kick them out early. There has to be a reason for it. After there is a breach of the lease, you're required to give the tenant a notice to vacate. It has to be in writing. After the period for the notice to vacate has expired, you can file the eviction in JP court. There in Harris County, we have 8 precincts, and in every precinct we have 2 places. You have to file it in the precinct where the home is located, and you can choose either place within the precinct. The tenant gets served by the constable. Only a constable can serve the eviction citation, the eviction suit, the lawsuit. It can't be done by a private service processor or anyone else. The eviction notice will have the trial date and information. And so at the trial, the trial's head, if the tenant loses the trial, if you win the eviction suit, the tenant has 2 options, and that's basically to appeal or not to appeal. If the tenant appeals, then there is a brand new trial at county court at law. That's where all the eviction appeals go. And that's only in downtown Houston at 201 Caroline, although all the hearings are via Zoom now. And if the tenant does not appeal, if the tenant does not move out, then the landlord's allowed to request a writ of possession, which is what allows the constable to physically remove the tenant from the premises. Next slide. So the time to appeal is 5 days after the eviction. So, and if that 5th day falls on a weekend or on a day that the court closes early, it goes to the next day. If it's appealed, like I said, it goes up to county court at law. It's trial de novo, which means it's a brand new trial. The county court at law judges generally do not want to hear what happened at JP court because it's a new trial. They're not discussing whether or not something was done right or wrong in the JP court. They're discussing the case brand new. In JP court, you are not required to have an attorney represent you. In JP court, you're not required to have an attorney represent you, but in county court at law, there are limitations on non-attorney representation. So just be aware of that if you're planning on representing yourself, that you may not be able to, depending on the nature, whether or not it's a multifamily complex and what the issue is. If either party wants to appeal from county court at law, that goes to the 1st or 14th Court of Appeals. That is not as common. That is not a new trial. That's looking to see whether or not there was an error or mistake made by the county court at law. And it's an expensive and lengthy process, and it's exceedingly difficult to do pro se. Next slide. So I just want, while I know that there's a lot of suffering going on across the country, and I know that landlords are feeling the brunt of some of it too, I just want y'all to be aware of the impact of evictions on tenants. When you have to find new housing, it's more difficult, and it often makes it more expensive. If there's evictions on people's records, the request for the security deposit goes up. I've seen some place, it just becomes more expensive. Moving is expensive. It means that children have to change schools. It causes instability in the kids' lives as well, and their schooling process and their education. If you can't afford to move everything, then families, not only do they lose where they live, but they lose what they own. It can get left behind. It can lead to job loss, because if you're having to show up to eviction trial or having to move and do things like that, it can interfere with someone's job. It also has adverse mental health impacts. There's higher rates of depression. And I know a lot of people think that like poverty causes eviction, but there's a strong evidence to support that like eviction causes poverty because of all of these issues above. Next slide. Or is that my last one? Thanks. Okay, so very briefly, just want to go over the CDC declaration. If a tenant gives someone a CDC declaration that applies, it means that you're not allowed to evict someone. It has been, as of yesterday, it's been extended to June 30th, 2021. It applies to all properties. It is separate from the CARES Act. I'm going to go over the CARES Act very, very briefly in just a second, but I've had some tenants tell me that the landlords say that their property doesn't fall under the CDC declaration. It does. It's all residential properties, every single one. It's been adopted by the Texas Supreme Court by emergency order. It's been adopted by the City of Houston by ordinance. just to be clear, there is no official form. I've heard some people say like they're not getting the right form. There's no official form. A lot of different service providers have created their own, version of the form. And by version, I mean the way it looks. The text is pretty much always the same. So there's no official form. If you're given it, you're not supposed to be evicting someone. If you want to read about the latest extension, this is the link. Next slide. When a landlord receives a CDC declaration from a tenant, you're not supposed to take any action that leads to an eviction. So you're not supposed to give a notice to vacate. You're not supposed to file an eviction. You're not supposed to request a judgment for an eviction. And you're not supposed to request a writ of possession after an eviction. Our courts are allowing for the evictions to be filed, but you are required under penalty of perjury or via declaration to tell the court if you received a CDC declaration so that the court knows when to schedule the trial. Next slide. I'm very briefly going to go over the CARES Act. That became effective over a year ago, March 27th, 2020. Section 4024, which is the only section I'm going to be discussing today, does not have an expiration date. The CARES Act only applies to some properties, according to the CARES Act, it's a covered property. And if you are a covered property, you're required to give a 30-day notice to tenants and to those tenants. Most lease agreements, as you know, if your property managers have a 24-hour notice to vacate, if you're a covered property, you're required to give a 30-day notice to vacate. Next slide. Covered properties are any federal housing programs covered by VAWA. That's public housing. That's if you have any tenants with Section 8 vouchers, you have a covered property. It's Section 8 project-based housing. You'll know if you're in any of these federal programs, you should know. But if you're if you lease to people with Section 8 voucher, the housing choice voucher, that makes it a covered property as well. The Section 202 is for housing for the elderly, the housing for people with disabilities, and a lot of, I'm not going to go through these. Next slide. It also includes additional federal programs, and the one that maybe is pretty common around Houston, in addition to the Section 8 voucher, is the low income housing tax credit property, the last one on here, LIHTC. That's actually an IRS program, not a HUD program, but it applies as well. If you're an LIHTC property, you're required to give a 30-day notice to vacate. Next slide. Just so you know, it also includes any property that has a federally backed mortgage loan. That's any HUD loan, USDA loan, FHA loan, VA loan, Ginnie Mae, Fannie Mae, or Freddie Mac. I know at the beginning of the CARES Act, we heard about Fannie Mae and Freddie Mac. It is any federally backed mortgage. Next. Very, very, very briefly, I just want to say, if you're wanting to work something out with your tenant, but you're having a hard time, the Harris County Dispute Resolution Center offers mediations for free. A mediator is a neutral third party that tries to help people reach an agreement. It is being conducted via Zoom. If you're wanting to try to work something out with a tenant, but having a hard time, it's also an option. And I know that I already said it, but I just really going to encourage everyone to sign up to be a participating landlord with the rental assistance programs offered through Texas Rent Relief or through HoustonHarrisHelp.org. Thank you.
Thank you so much, Ms. Everett. That was a lot of information, especially about the eviction process. So now we're going to take some questions. Some questions have been previously submitted, but I know that we also have some in the chat. So we'll try to get a combination of both of those questions. And what I'll do is read the questions out loud, and then Ms. Everett or Mr. Bookstaff or Kimmy can answer those questions accordingly. So the first question that I have is, if a delinquent tenant, and this applies for COVID relief, if a delinquent tenant has applied for rental assistance and has not made efforts to pay rent from their own income sources, is the landlord eligible to receive rental assistance payments for past due rent if they file eviction?
Lisa,
Do you want me to start, or do you want to go, Howard?
Go ahead, Lisa.
If you receive the money, you're supposed to dismiss the lawsuit. I don't quite understand the distinction between whether or not the tenant is making partial payments or not, but if you receive the rental assistance money, you're supposed to dismiss the lawsuit, the eviction lawsuit.
Yeah, I tell people before you agree to a rental assistance program, number one, read the requirements of the program. There's usually a landlord certification off of the website. I know the Baker Ripley, the Houston Harris County one have it on their website. The Rent Relief has it. The Texas Eviction Diversion Program has it. And so be sure to read the requirements before you agree to take the money. You have to understand that the intent behind these programs is not to get a landlord money to decrease the delinquency of a tenant. It's to avoid eviction. Okay, so we've been in the landlord part of this is we've been asking for rent relief since last March for a year, more than a year now. Our position has been that the evictions is not the cause of the problem, it's the result of the problem. The problem is the delinquencies. And so the reason why the intent behind these rental assistance programs are to avoid evictions, so you can usually expect that once you sign up for the program and a tenant who applies for the program, you're not going to be able to go further in an eviction process. And once the tenant actually gets money from the program, you're going to rescind or dismiss your case. And again, the intent is not to evict if you're getting money, and the intent is that if you're getting money, if you actually receive money for a period of time that you're claiming the delinquency is for, there should be no need to go forward with that eviction. So go into it with that in mind, not thinking, and we've been asked, well, the resident's going to leave next month and they owe a bunch of money. Can we get all the delinquency paid through rent assistance? And I don't think you can ask the rent assistance administrator of that program that you're talking about, but I would anticipate a response that no, if you're going to evict somebody, we're not interested in giving you the rent assistance.
And you can actually be required to return it if you don't if you continue with an eviction for money if you receive money.
If a landlord has a tenant that has been economically impacted due to COVID-19, they have a job, but they're not making enough money to pay the market rental rate. And so they're making partial payments on their rent. What recourse does the landlord or owner have to recoup losses?
Apply for rent assistance. It can pay those partial payments that's been left delinquent by the tenant. You can say how much is delinquent from each month. You're muted, Howard.
Yes, I was. Yes, I was. I was thinking anyway. I wasn't really speaking. So pre-COVID, I would say the landlord's primary remedy for non-payment was the eviction process. Since COVID, we've had a very confusing, complicated, drawn-out eviction process, starting with the moratorium the first couple of months of COVID in March through May, and then leading to the CARES Act issues, and then that was a moratorium for certain properties, and now we have the CDC declaration. So you still have the right to evict, subject to the CDC order and CDC declaration. So you'd look at that. Now, if somebody gives you a CDC declaration and they really have made timely partial payments as close to the full amount as they can do, they made their best efforts, you're probably not going to be able to contest successfully the CDC declaration. So it's a good idea to work with them. And as Lisa says, one of the ways we've been fighting is from the landlord side because a lot of people were working with their tenants pre any rent assistance. We were doing partial payment plans in March, April, May, and some people were waiving delinquencies, waiving late fees, doing everything the rent assistance program asked you to do, but they were doing it without any strings attached, any rent assistance getting any benefit to them. And so we're still in that sort of mentality where you should work with your tenant. The rent assistance program hopefully will help you, as Lisa said, hopefully make up the difference if it's an otherwise a good tenant. Now, keep in mind that there is no rental assistance program. There's no caveat under state, local law that says the resident still doesn't have to pay rent. The obligation to pay rent still exists. And so keep that in mind. And if the resident is not cooperating, they haven't paid you in several months, they're ghosting your efforts, the CDC really is not supposed to protect them from that. And that's designed to, if they give you a CDC declaration, you contest the declaration in court, and it's up to the justice of the peace whether to grant it or not. But if somebody is working with you, that's when you would want to embrace them and try to get the rental assistance program to benefit the tenant and to pay the delinquency to you.
So here's kind of a follow-up question to that. If the tenant does not qualify for rental assistance, is it safe to assume that they are not going through hardships and that they are capable of paying rental costs? And also, should you proceed with the eviction process for non-payment?
Can I comment on part of that? There are priorities for the programs. For example, the Texas Rent Relief is, there's a priority. You have to be at 80% or less of the area median income, but there's a priority given to those that are 50% or less. And so just because someone doesn't qualify doesn't mean they're not going through a hardship. And I would just like to point that out.
Howard, you're muted.
I was thinking again. No, I was trying to talk that time. Every situation needs to be evaluated on its own merits, its own facts. If you don't have a CDC declaration, it is business as usual, subject to a 30-day notice under the CARES Act, as Lisa alluded to. But it's pretty much business as usual. Once you get a CDC declaration, then you have to look at the situation and assuming the content. It doesn't have to be on the CDC form, but it does have to have the 5 statements made under penalty of perjury. They've used their best efforts to get government assistance. They made less than $99,000, which frankly we have never contested that, because I think a lot of people could qualify for your rental without making $99,000. At any rate, best efforts to government assistance. They would be homeless if evicted. Best efforts to make timely partial payments as close to the full amount as they can, and they've had a loss of household income. If you can show that one of those things is not accurate, you have to provide evidence to the justice of the peace. But the Supreme Court of Texas has given us a procedure to contest these, and so if you think it's not correct, you contest it. And it's up to the judge whether to grant it or not, but at least you're trying to do something if the resident is not cooperating with trying to get rental assistance or ghosting you because they're not working with you on payment programs or whatever. So that still is your right to do that. And
I'm going to follow up on one thing. The tenant submits it under penalty of perjury, but the landlords aren't supposed to contest in bad faith, and the White House is fine, and it's supposedly prosecutable by the Department of Justice. The White House issued a memo yesterday encouraging people to report landlord abusers to the Consumer Financial Protection Bureau.
Interesting. I did not know that. And I do want to let everybody know who's attending that we are running short on time. We have so many questions, so we're going to try to answer as many as we can. So if you guys want to stay on past the time, that's perfectly fine. Here's a question about ESA animals. So this question says that it seems that a landlord or property manager, or as a landlord or property manager, we're not allowed to get specifics on the tenant's illness, and residents have been taking undue advantage of this law. um, so that they can, avoid paying that pet deposit. What can be asked to ensure the animal is an assistance animal? I know you kind of covered this, Howard, but if you can just kind of hit home on that just a little bit more.
I mean, that's a great question, and one that there's no easy answer. What I like to do in my responses is, as I said, I put my responses in writing to make sure there's no misunderstanding, miscommunication of what we want. But I will tell a person that, we need to verify certain things, because there are a lot of fraudulent cases out there where it's very easy to buy a registration certificate or a letter from an internet doctor to get that approval. If you think that there's something up with the situation, then you can ask. I always phrase it the same way. I give them the questions HUD says is we need further information, reliable disability-related information that verifies that you are disabled under the Act. I'm not interested in the nature and severity of their disability. I just want to know they have a disability under the Act, if that's a question, and the other, if that's the circumstances merit that question. And the other question that we commonly ask on assistance animals is reliable disability-related information that shows the relationship between the disability and the request, i.e., and then I use HUD's words: does the animal work, provide assistance, perform tasks for the benefit of the person with a disability? And I am looking for specifics from their healthcare provider on what are the, as the case in 2017 said, what is your physical or mental impairment that substantially limits one or more major life activities? That's what we're looking for to say yes. I will caution you, don't be the landlord that just says no. You need to know what yes looks like if you're going to push back on somebody. In other words, there's got to be a scenario where you would say yes if they provided you with certain information. I'm reluctant to tell the resident exactly what I'm looking for in terms of language from a letter, because I can't limit, the law doesn't allow me to limit them to just that. They can provide me anything they want, and I have to evaluate everything. Not necessarily evaluation means approval, but I'm going to evaluate anything they give to us. So I know that doesn't really answer the question, but it just depends on the circumstances, how obvious it is that there's a fraudulent situation, or how obvious it is it's a legitimate situation. So we base it on the facts of every particular case.
And can I piggyback on for just a second? One thing that Howard says to do is to give a response in writing. I think that's a great idea. No response is legally a denial, and denial is normally not a good idea. An outright denial for no good reason.
What if you were going to evict before before COVID-19 pandemic hit, before the CDC moratorium? Does the moratorium still apply?
If you haven't filed an eviction already, then everything is in effect. I mean, if someone qualifies under the CDC declaration now and you hadn't already filed prior to the pandemic, then it applies.
Yeah, I would agree it applies, and you can evaluate. I mean, that may be evidence of some type to contest the CDC declaration if they have no household loss of income since the pandemic began. But you'd have to do not, as Lisa said, she talked about the federal folks watching you as far as ways to enforce the CDC order, which has very substantial penalties. I might mention not only the federal, but the local. The city of Houston, when it adopted it's called its grace period ordinance, but it's really not a grace period ordinance. It really adopts the CDC declaration, the CDC order, and there's a city way to report you to the feds as well if they perceive that you're violating the CDC order. So I always tell people, don't ever ignore a CDC order that you got. Even if I have a criminal case, like a case involving criminal, and I'm evicting them for criminal conduct, which is a clear, okay under the CDC order, I still phrase it like I'm contesting the CDC order because the CDC order shouldn't apply to my case. So I'm very conservative when it comes to recognizing that there's a CDC order that has been submitted to me, but for whatever reason, I contested. I think this eviction should go forward even with the CDC order because of this, or this. And I tell the tenant up front, this is what we're doing. And I tell the judge the same thing and try to produce whatever evidence I can to contest the declaration.
Great, thank you. So another question is, if a landlord thinks that the tenant is fraudulently using the moratorium, and a landlord has asked the tenant to move out, how long does the landlord have to cover the tenant staying in the property without payment? And I know that this question is so detailed, it may require some advice outside of this, but if you have any advice, what would you say?
Lisa, you want me to take that? Okay, so I'm not sure I understand the whole question, but I got glimpses of what the landlord might be thinking. How long is it for you to cover? When you're providing housing for the tenant, it is very dangerous for a landlord to suddenly, let's say, stop repairs that are needed because the person hasn't paid rent. Statutorily, and one of the chapters of the property code Lisa mentioned was chapter 92, that does have a repair and remedy statute to it, where it does decrease the ability of a tenant to exercise certain repairs if they haven't paid rent during the time they're requesting a repair. But don't get fooled, landlords, into thinking I don't have to repair because they haven't paid rent. There are other causes of action that may be available to the tenant if you are negligent, if you and so one could argue that, right? So I'm not saying you are, I'm not saying you're not, but that could be the argument. So you really don't want to, not fix the air conditioning problem or a mold problem, a potential mold problem just because they didn't pay rent. It is still your property that you need to take care of. So that becomes a very slippery slope. I would rather have you, again, evict, and if it's a CDC declaration, contest the declaration, or if there's only a monetary issue, get the rental assistance. But if they're not cooperating, that's one in your favor for the CDC contest. So there's a way to go about doing it, but I would not suggest ignoring repairs because they didn't pay rent.
Lisa, did you have something you wanted to add to that? Okay. Another question is, what is the impact of the eviction moratorium if the landlord does not renew the lease and gives 30 days notice for non-compliance?
I think you're going to get a different answer from Howard than you get from me. It's our contention that the CDC declaration is not intended to allow people to evict what you're describing would be a holdover tenant. If you would have otherwise renewed the lease except for non-payment of rent. But I know that we've seen that the landlord attorneys and the landlord, their representatives definitely disagree with that contention.
Yeah, I think it's going to be subject to interpretation of the CDC order. Again, if you don't have a CDC declaration, it's business as usual. I actually think there may be a difference between if you give a holdover, if you give a notice to terminate a lease before you get the CDC declaration, I don't think you've taken, well, and then you get a CDC declaration after you give the notice of lease termination, but before the notice to vacate when they're actually a holdover. I think there's an argument you did not take any action to remove or cause the removal by giving your termination notice and your subsequent notice to vacate, which is, again, after the CDC declaration, but just in line with your notice of lease termination. Now, having said that, again, conservative belt and suspenders, I would contest the CDC declaration. In most of my cases where I'm contesting the CDC declaration, they've made no effort to pay us. So that's a valid way to contest the CDC declaration. So even though I'm going on a holdover, I'm contesting the CDC declaration because I want to be real conservative, not to have an allegation against me that I'm violating the CDC order. Hopefully that makes sense.
No, thank you. And I know you have different interpretations of that, so thank you for giving me both sides. I'm going to wrap up here with another few questions, and then we'll let you guys go. Under the COVID moratorium, what is the current treatment of foreclosures?
I don't think it, the CDC declaration applies to post-foreclosure evictions.
Yeah, I would agree. I would agree. It's the landlord. Yeah. Now I know foreclosures. There has been delay in foreclosures in Harris County because the court's been closed, and so I'm not sure where the person wants to go with the question and so forth. But there has been issues on doing foreclosures, but the CDC I don't think applies to it
unless you've entered into a lease agreement with the person living there.
I will close with this last question, and this actually is geared towards repairs from the winter storm. So I don't know if you guys want to touch on this, but I'll ask it anyway. If the property is uninhabitable due to the winter storm, and the tenant is still dealing with the insurance company, but they vacated and they've submitted a letter to surrender the property, but they've left some damaged personal property from the storm, can the landlords recoup their itemized expenses for removal of that property or the damages from that security deposit? I know that's a lot in that question. Does that make sense?
I'll let Lisa take the insurance. I think the tenant asking, the question is over the tenant's insurance.
I think I don't understand that aspect of it, but if a tenant has, sorry, and I'm not trying to talk over you, Howard, but if the tenant's vacated the property, you follow the lease and the property code regarding deducting for security deposits.
Right, they would owe, if the unit's not habitable, they would owe the refund of the deposit and refund of any rent paid after the termination of the lease, less lawful deductions. So those lawful deductions could be damages, but I would think they're not going to be damages that are because of the winter storm, but damages that the tenant caused to the unit unrelated to the winter storm.
It to me also sounds like maybe a cleanup from personal property left behind.
Yeah, and I would think if the tenant has abandoned personal property and the landlord incurs expenses removing that, the landlord could charge, unless the lease says otherwise, the standard TA lease I think would allow this, that the landlord could charge the tenant for those expenses and deduct from the deposit those expenses.
Thank you. I know that was a tough question.
I saw a question about the time it's taking to get the payments. I'm not going to hide behind the fact that it's been painfully slow. It has been, but I'm getting, like, I got a notice right before this meeting started of someone who told me they were under review, and it's my understanding the landlord is also getting a notice when they say that it's under review that the payment was distributed. So it is happening. It is happening. It's under review, and I hope we're telling them they need to move faster. Just so you know.
Yeah, ditto on that. I think that we've gotten good reviews from the Baker Ripley piece, the Houston City of Houston Harris County deal. The rent relief has been problematic, but I mean, they're working on it. We're asking them to work on it, and hopefully things will be straightened out. The good news is they got lots of money. and they have more money under the American Rescue Plan from the Consolidated Appropriations Act, is where it started. The bad news is, their big rollout was February 15th, which most of Texas was dealing with the freeze. So that created issues as well. So stick with the program. But again, as a landlord, you want to have a game plan for how long you're going to wait for the money, and then you're going to proceed if you don't get the money. So just have a game plan and know with eyes open what you're getting yourself into.
Sorry, Lisa and Howard, I actually have maybe two more questions if you don't mind. Can you contest the declaration for breach of contract if a tenant has unauthorized occupants?
I'm gonna let Howard take that one.
Yeah, so it wouldn't, again, my conservative interpretation is I'm going to give you the belt and suspenders approach, because the non-belt and suspenders approach is that the CDC declaration does not apply to a breach of contract. So that is clear. It does not, there's no interpretation needed. It does not apply to a breach of contract. Having an unauthorized occupant is a breach of contract. So one could say you didn't violate the CDC order if you ignored the CDC declaration because you had a breach of contract case, not a non-payment of rent case. Belt and suspenders, I still acknowledge getting it. I still say I got it, but we're going to still say it's not valid in this case because we have a breach of contract. So I would explain away that I never want a judge thinking that I am trying to hide the fact that I got the CDC declaration. I mean, you really can't under the Supreme Court guidance, Supreme Court emergency orders. They say that, they ask you if you got one, you got to tell the court, and the tenant has to do the same. So I would never hide behind it. I would attack it, and I would say, look, we got the CDC declaration, but we have a breach of contract here, so it shouldn't apply to it. It's always going to be up to the judge. The judge is going to be the finder here of whether the contest is valid, whether the CDC declaration is valid, and whether the eviction process should go forward.
Thank you. So I will definitely close with this last question. What if a tenant refuses to make a payment and won't apply for rental assistance, but signed a CDC order? Can the landlord still file for eviction?
Contest the declaration. Your evidence, they seem to have violated at least two things in what they said under penalty of perjury in the declaration. They said they used best efforts to obtain government assistance. And if you have made government assistance available to your residents by enrolling in a program, and this particular resident has not even applied, if they applied and didn't get in, that's not going to be evidence to support that they didn't use their best efforts. But if they didn't apply, then I would say they didn't use their best efforts for government assistance. And the timely partial payment, which is the most popular one we can test, you can't, the residents got to understand, they can't give you a CDC declaration and then ignore you for months and not pay you. That's not what the CDC declaration says. That's not what the intent is. That's not what the way it goes. So that would be the evidence you'd bring to the judge. Now, it may take longer. It may involve you're obviously at the discretion of the judge, but you need to produce the information that and give it to the judge and say, Judge, we don't think this is a valid CDC declaration. We want the eviction process to continue, and let the judge determine it.
I'm just going to follow up on that really quick. There was someone asked, like, don't they have to pay 25% or something? There is no minimum requirement. The CDC declaration says, I have done my best to make timely partial payments that are as close to the possible payment, to the full payment, and to get government assistance. This is a weird, sorry, it's on the CDC website. It says taking into account your other expenses. If like, let's say you're a two-income household and you have children, and one person's laid off and one person's like barely eking by, and you're putting food on the table or paying rent, it is not requiring you to starve your kids in order to make a partial payment. And I want to make that clear as well. And we are encouraging, like, the tenants are coming to us. I tell everyone they need to be making the partial payments. everyone. And some people say, I can't, and they'll start crying, and they can't. They can't. It doesn't require that. It requires their best effort. And for some people, that's going to be zero, and for some people, it's going to be something way more substantial.
No, thank you so much for that. Both are very valid. So thank you so much. I also want to just thank you both for being here with us and giving us so much great information. I know that we're totally over time. So just again, thank you so much, Howard. Thank you so much, Lisa. Before we go, there are a few resources that we want to remind all of our landlords and tenants about. So please do not forget to enroll as a landlord at HoustonHarrisHelp.org, or you can call this number that's on the screen. Please pass this information along to all of those who need it, and let's help our Houstonians economically recover from this pandemic. Also, please tell us what home means to you. You can go to myhomeishere.org to take a short survey. Both Harris County and the City of Houston want to learn how to improve the Houston area, and you can do that by giving us your opinions here through this survey. And the last day to take it is actually tomorrow, so please take it today. And with that, we just want to thank you all for joining us. Please follow us on Instagram, Twitter, and Facebook at Houston HCDD. And if you haven't already done so, please sign up for our monthly newsletter where you can get more information about our upcoming events and training. Thank you so much and have a good afternoon.
Thank you, everybody. Bye.
Thanks for having me as well.